Everybody, I thought I'd take this chance to review some of your questions concerning the case involving LaShawn McCoy. In any event, Mike asks a good question starting out, and his question was, when will they tell you the exact amount that they want? Probably never. In this case, we have a matter of what's called unliquidated damages. Liquidated damages would be if I had lent you my wallet to hold and it had $10 in it and you returned it to me and the $10 was missing. We'd know that my damages were $10 and probably some interest. In a case like this, where someone suffered a broken nose, broken ribs, they've experienced what's called pain and suffering. And in that situation, nobody really knows what that amount is until the jury that hears the case decides what the award is going to be. So you are never to plead an exact amount of damages when it's pain and suffering. So I thought I'd start with that. A lot of folks had questions about the question of security in front of the establishment, but complaining about security in the lounge itself. And basically, I think what they're trying to say is that they did recognize there was a need for security so that they screened people coming in. But I think that their contention will probably be that there was not enough security in the lounge itself where the patrons were. It's an interesting question. Many people were concerned with that. And when you plead something like this, when you plead this kind of a cause of action, you can plead it in the alternative. You can say that they should have had more security. You could say they had security here but didn't have security there. So that didn't seem out of the ordinary to me, but I'm sort of used to seeing some of these things. So a couple of good questions were raised about the question of security. How would you prove that they didn't have adequate security? Well, there's a couple things. One would be I'd like to perhaps use you all as jurors, and let's see down the road. I may have some clips to show you that show some of the dispute on the night in question. As I recall, it's quite a melee. It seems to be involving 4 or 5 different people. There are a couple of professional football players, and I think the defendant cops were big guys. So this was quite a tussle. And it sounds like, and it's amidst what's the techno pop. Am I showing my age, everybody? Please forgive me, but it's got a strobe light going. It's got really loud music. And on top of that, you have a struggle among 4 to 6 people that's pretty heated and things are breaking. It's not a pretty picture, but see for yourself whether you think there was enough security. Maybe they couldn't have stopped, say, a fight, but this tussle seems to go on a while. It seemed like it did to me. But here's the question, everybody. Could I be a witness about the level of security at a nightclub? I think no. I think that's a question of expertise. So I think this would be an area where the plaintiffs would probably get an expert to testify as their witness, and I expect that witness would evaluate the records, would evaluate the night in question, and I'm guessing would come up with an opinion that the security was inadequate, and that would be the use of experts. That's an important area, everybody, the use of experts. And that's basically when you have an issue that can't be decided by jurors. So this leads me to another good question involving one that you all raised. One was intoxication. How would they prove there was intoxication? Well, intoxication is one thing that as average citizens, we are supposed to have enough personal experience in our lifetimes to have a sense of when someone's intoxicated or not. They're supposed to be visibly intoxicated, as I recall the statute. And I can tell you that the liquor establishments are held to a very high standard. They're not supposed to be serving intoxicated patrons at all. So they're supposed to, and their waiters and waitresses have very clear instructions about that. And most places nowadays, I think, are fairly rigorous about that. Somebody's probably laughing. Maybe I'm out of touch, but I think that the liquor license requirements in Pennsylvania seem tough to me. And I would think that the question of serving intoxicated patrons would be a serious one that restaurants would want to look after. I was involved in a liquor license revocation action one time as an attorney, and the restaurant had spent $1 million just building the building itself, so they had a lot at stake. I can also tell you I was involved in another liquor license case with I guess we'd call it a bad license. That is, it was a liquor license given to a group of people that weren't good citizens in terms of running their liquor operation. And the bar became really a problem spot in the sense that for whatever reason, when people get together with alcohol, they get a little bit funny, and they caused an awful lot of difficulties for the police department. So over a very short period of time, they had any number of serious calls there for injuries, as it turns out, both inside and outside the bar. When people get drinking, they get to fighting, and that's what would happen at this place because there was poor supervision. So you got to see a fairly clear application of why these licenses are important, why the Dram Shop Act is probably strictly enforced. There was another, also with respect to expert witnesses, getting back to my topic, with respect to expert witnesses, you could also have a witness go backward from the testimony of the participants if they told you clearly how much they'd had to drink, and an expert could do a calculation backwards. This proof, by the way, of intoxication is not necessarily that you would use for a criminal case in driving while intoxicated. It would be a different kind of level of proof. It would be whether an average individual, even somewhat trained individual, could tell whether someone was visibly intoxicated. Those indicators would be just what you and I would know if we were asked. It would probably be, say, slurred speech, red eyes, bad balance, odor of what smells like an alcoholic beverage emanating from their breath, lack of stability in their standing, and any number of redness. Some people get red in the face. Be a number of possibilities that you could raise as to why you thought someone was intoxicated. So that would be how the intoxication in this particular case would be determined, and the jury would be the one that would decide it. Somebody, and I'm going to skip their name, mentioned why would the court set this forward, meaning the complaint. Keep this in mind, everybody. The complaint is created by the plaintiff. It's not been proved yet. So keep that in mind. This is what the plaintiff says. Some good questions about emotional distress. How would you prove the intentional infliction of emotional distress? Well, firstly, we usually prove intent by people's actions. In other words, if I throw something down the stairs, someone could say, did he say what his intent was? No, I didn't. But I did intentionally throw something down the steps. I did, through my own force and effort, take something into my possession and throw it down the steps. I think you could infer my intent from that. If somebody does something that would clearly inflict emotional distress on someone, I think that would also be an indication of their intent. Another question would be, how would you prove this emotional distress? The same way, that would be an expert as well. If someone were to have experienced this episode and then gone to a psychiatrist for a period of time, that would be an indication of their emotional distress, or a change of their life or change of their features. If someone had simply gone to a counselor, that would be an indication of emotional distress. Let's see, any others? I know. Kuma had a good comment about what is the ratio of security officer to patron. That's a question for an expert. In other words, if I told you I don't know that would be secondhand information from me or presumably you. In that situation, that would be something that an expert would testify to, and they'd closely look at what their records were that evening, what the videos showed, and go from there. I think that's pretty much it, everybody. There were some good questions. I hope these are helpful to you, and I will see you later.